So this is the agenda for today. So we'll be reviewing some of the important topics of CIPP, and we will be doing some CIPP exam preparation discussion, and we'll also look into few of the data privacy interview questions and our plan in terms of how do we clear the exam within 2 months and opportunities for data privacy. These are the agenda which we'll be discussing today's webinar. To start with, so what are the different certifications which are available for data privacy currently? So there are four important benchmark certifications which are there, which are from IAPP. The first one is CIPP, which stands for Certified Information Privacy Professional. There are multiple variants, one for Europe and second for Canada, third for USA, and the fourth is for Asia. And among the four variant, the Europe is the gold standard generally. And if you complete GDPR, which is CIPPE, then you can definitely take it forward for any other specific jurisdiction. And CIPM is Certified Privacy Manager. So it's again a very important course which gives you the mileage in terms of you handling the entire privacy program for an organization. So the sequence or the ladder of how do you progress is CAPPE gives you the entire basics of the law, the data protection law of Europe, which goes in very detail. And then CAPM is the next sequential order because in CAPM we do not go into the basics of data privacy, but rather we directly jump into how do we handle a data privacy program, how do you think like a privacy manager, how do you handle privacy data protection on a day-to-day basis. So this is the main difference between CIPPE and CIPM. CIPT is for privacy technologist, and this course is targeted towards developers and IT tool creators. So mainly, how do you embed data privacy requirements right from the tool creation, solution creation, as well as the program management. So this is mainly towards for developers and solution makers, and this course is something which we will encourage for people who want to take a alternate switch from developing. How do I actually make a unique landmark for myself? So this is the difference of CIPT, CIPM, and CIPP. We also have CDPSC and CIPT is almost equivalent in terms of the scope and in terms of how do we actually leverage this particular certification. But CIPP, CIPM is very important from a privacy practitioner perspective. And if you complete either of the two and show 5 years of experience, then you will be eligible to get this tag of FIP, which is Fellow in Privacy. And this very few people in the world currently have this title. It's a very important title which uniquely sets you apart from any other competitor applying for any data privacy role. So that's a brief among the different data privacy certification. And today we will be focusing on CIPPE. And to start with, we are going to discuss on some of the important areas or topics in CIPPE. So I'll not be with interest of time. I'll not be able to go through each and every topic in detail, but rather I'll give you a glimpse of what you will be discussing, what you can expect in my sessions, and how do I take it forward from there. But the content whichever is going to be presented is not the actual content, because those are all IAPP's material which will not be able to share in webinar. But these are the materials which I'll be using right now is a very common and standard one. To start with, we are going to discuss about what is personal data. If you see, there is a lot of difference between personal data and even at a level of is it personal information or personal data. And there is also something called the data privacy and information security. So there is a lot of terminologies and jargons which has been there in the circuit for a longer time, and many people gets confused with these basic terminology. In fact, if you see GDPR, general data protection is more into your data protection than data privacy, right? So there is a difference between all these terms, and this is something which is very important for you as a data privacy practitioner or someone who's interested to know this field should have a fair idea about. To start with, we discuss about what is personal data. So personal data is any information about a person, and that person has to be a living person, right? So any information which is relating to identified or identifiable natural person is called personal data under GDPR. So in this, any information, the information can be objective or subjective. Many times we always think GDPR is like electronic data, which means financial data, or we can look into our ID information. Those are the only personal data, but there is a lot of interesting things which you will be which will get clarified during the course. For instance, even subjective information, like for example, if you're working in a company, HR is your work, you're filling your appraisal, and your manager puts a comment about you. Even those comments, which are quite subjective in nature, can also become part of your personal data definition. And even statements which are true or false, even a statement that could be false but still can be covered under GDPR material scope. So these are something very important nuances which I'll be covering with a lot of examples in my session. And so we'll also be looking into professional data, technical data, part of GDPR definition. And also the formats include your paper formats and your electronic formats. So in paper formats also we have a big limitation. Not every single paper format will be included part of GDPR. There are only specific type of paper format which will be part of the GDPR, which is a very important question in the exam as well, which we'll be discussing in sessions. And then any data has to be related to a person. When we say related to, then it has to fall under these three categories. One, the actual content of that particular information or the data, the purpose of that particular statement, or the purpose of that particular process whichever you are handling, and the result. So all these things has to relate back to a person, natural person. Then only this particular statement can become a personal data. Okay. The third is identified or identifiable, which means many a times there are directly identifiable information. For instance, let's take our Aadhaar card or PAN card, your passport. All these are directly identified person. Any piece of information which can be directly related to a person is called identified person. Identifiable means there are pieces of information. For instance, your date of birth, your blood group. Your blood group and date of birth cannot reveal exactly who you are. But when you combine certain fields with that, sometimes even name is not a unique field, correct? There are many common names across in India. So when you combine your personal data, then it becomes a uniquely identifiable data. So these factors of singling out, combining indirect data, all these terminologies are very, very important in terms of how do you save, protect, and manage these directly identifiable as well as your indirectly identifiable personal data. Then very important part is all these information which is related to a natural person, and the natural person should be a living person. In GDPR, people who are deceased, their data are excluded. Any company's data or organization data is completely excluded. Okay. So what is PII? PII is a personally identifiable information. Personally identifiable information is, as I said, it's a terminology which is a subset of personal data. When you can uniquely identify a person, it becomes a PII. So we have sensitive personal data. In GDPR, we have around eight straight categories of sensitive personal data. And so some example include your trade union membership, your affiliation with certain trade unions, your health data, your genetic data. Genetic data here refers to your DNA, RNA data, because that particular data can trace back your entire origins, right? It can tell your race, your ethnicity, and everything can be revealed from your genetic data. Religious belief is definitely a sensitive data. Political belief again has a lot of ramification or repercussion in your particular work environment. That's the reason political belief is absolutely a sensitive data. Biometric data is again very important, sensitive data. Biometric data is not always your fingerprints. Biometric data includes a large subset. For example, your photograph can also become a biometric data if it can uniquely identify a person. Your face is a biometric data, your fingerprint, your iris, your eyes. There is a lot of biometric data that is being taken from us on a day-to-day basis, right? Race and ethnic origin, sexual life or sexual orientation, these are all examples of your sensitive personal data. So then I'm touching another important topic, which is your territorial scope. So in territorial scope is a very interesting topic because many a times we think GDPR is only applicable to a European citizen or European resident, right? For example, we think GDPR is applicable only to a person who is living within Europe. Actually, absolutely not right. The reason is GDPR has something called extraterritorial scope. So GDPR can apply to a company which is based out of India. GDPR can provide the rights to a person who is living in India as well. So there are a lot of interesting scenarios in this particular topic. In my session, I will give you at least 7 to 8 different case studies to understand this territorial scope in detail. But here, a shortcut to remember territorial scope is that if the company is situated within European Union, we call it the terminology as establishment. If there is if there's an establishment which is based out of EU, then GDPR is applicable. The second and third clauses are very interesting. The second clause is that if for a company which is not based out of EU but still providing goods and services to the data subject, then GDPR is applicable. Or the company which is not based out of EU but still monitoring the behavior which is taking place in the EU, then GDPR is applicable. So there is a lot of interesting derivatives which can be pulled out of this particular statements, because what do you mean by establishment? Then we need to also look at the exact terminology which is there in GDPR, which says that you have to specifically target a data subject. So what do you mean by specific targeting? So for this, you need to know a lot of examples, and those examples give you the absolute clarity. How do you face the questions whenever you meet an exam, as well as you solve these things in your day-to-day practice as a data protection data privacy professional. Okay, so moving on, I'll be touching upon the lawful basis. So in GDPR, we have 6 important lawful basis for processing any personal data. So we also have around 7 principles, and the first principle is called lawfulness. In that principle, if you do not process the personal data out of any of the 6 approved lawful basis, then you are breaching the principle of lawfulness. So that is a very very important requirement, and that is the reason we should be absolutely sure in terms of what is the basis for which we are processing personal data. The first one is consent. Whenever a data subject is giving his direct permission to process the data. Second is a contract. A contract is between a buyer and a seller. It is the majority of that is used in many goods and services by a buyer and a seller. That is a contract. Third is legal obligation, specifically used by the rule of law in that particular country. Example, the banks give the data for GSTN or your income tax authorities, human resource. So there is a lot of legal obligation, court orders. There's a lot of legal obligation for which personal data is being transferred or it's being shared. Vital interest is life and death situation of any patient. In that situation, when a patient is not able to provide his information, you can actually open his wallet or look for his ID card, try to look at that number, call that person, reach out this, extract that personal data and save his life. So that is a vital interest. And fifth is public task, majoritarily used by the government agencies for a noble public reason, and those reasons majority are for the public good. And sixth one is legitimate interest. The very very notorious and very important lawful basis is legitimate interest. Why I say notorious is many companies can misuse this. At the same time, it's one of the very valid and important instrument for the companies, and this is one of the highly scrutinized one from the GDPR officials perspective as well. So in this, we in our sessions we will be looking into the depth of what is a valid consent. There is a lot of scenarios where consent may not be valid. For instance, if you look into the employee employer scenario, if you're working in a company, if employer is trying to take a consent from you during the course of joining, it is generally not considered as a valid consent because you are already under a lot of pressure, and there is an unequal balance of power between the employer and the employee, right? So generally contract is a suitable mechanism for processing personal data in an employment contract rather than using a consent. So in this way, like, we have so many intricacies we will be discussing in all these lawful bases with a lot of examples, and especially in legitimate interest we need to do a lot of documentation. We have to do something called legitimate impact assessment, we call it as LIA, and all these things I'll be sharing you more insights during our session, how to conduct all these things. So the next topic, important topic, is DSR, which is data subject rights. For data subject rights, again, this is one of the fulcrum of the entire data protection law. The reason is every law has been developed to empower the citizens or the common people, right? And the important tool for through which you empower is data subject rights. And so we have these set of data subject rights available for European resident through the GDPR. The first one is right to information, requesting information about whether they are processing your data, or you can ask a lot of questions about this particular processing. Right to access is you can request for a copy of your personal data. Third, rectification, you want to make changes to your data which is already shared. Erasure is, for example, you want to remove your data, which is called right to erasure. Remember, all these rights are not absolute rights, which is very, very important, because when you say absolute rights, then all these rights, whenever is being requested, has to be fulfilled without any deviation. But there are certain exemptions, which is very, very important from your exam perspective. I'll be covering that in a specific table in terms of what are the interplay between the rights and the lawful basis. Okay. Again, right to restriction is like temporary hold on the processing. This also has certain exemptions which we need to know. Right to portability, moving the data from one electronic form to another company with the free of charge. So you know, don't need to again fill the KYC form to another company. Right to objection, again, requesting you to not process my data under this particular processing. Again, these has a lot of limitation. Only in few types of processing you can raise right to objection. The final right is right against your automated decision making. Automated decision making is a computer can decide on certain processing results. For instance, there is a loan operation where there is a computer based on the data which he has provided will decide the probability of providing the loan to the particular individual based on the parameters like your income, your previous your credit history, your current in terms of your salary, and in terms of for example, if there is any you are not paid your dues. All these things are important factors for calculating your civil score. And civil score, based on that, a computer is able to find to give a result. Yes, we can give a loan to him, or you shouldn't give a loan to him, is an example of automated decision making. So such kind of processing needs to be informed prior to the data subject, and the data subject has an option to say no to automated decision making. Again, it's not a blanket statement. There are certain nuances which we need to take it forward. For example, it has to have a legal impact on that particular individual. So all these things are something which we will be discussing in detail, and especially these rights are not absolute rights, and there's a lot of interplay between the rights and the lawful basis, which we'll be discussing in our sessions in detail. And data breach notification is one of the very important topic, because in GDPR we have a mandatory requirement of notification within 72 hours. And so in this particular topic, there are two important notification. One notification is with the supervisory authority, and second notification with the data subject. So in this we will be discussing in terms of in what conditions you will be intimating the supervisory authority, and in what conditions you will be notifying the data subject. What are the examples? I'll be giving lot of interesting scenarios and case studies to make you understand this concept completely. And as I said, my sessions are always case study oriented. I'll be giving you practical case studies which you can expect in the exam. How do you handle this particular situation? Do you notify the supervisory authority or not? Do you notify the data subject or not? When you notify, what are the analysis you need to do? Okay, and what sort of assessment you should document for your supervisory authority, right? So we'll be discussing all these things in detail, and it's a very important topic from your exam as well as privacy consultant role as well. Accountability requirement, one of the very important exam topics as well as important topic for your day-to-day work. The the, the important accountability requirements require that you need to maintain internal records, that we call it as ROPA, records of processing activity. So in my session I'll give you a template of ROPA, and what are the important details that you need to record. Part of the ROPA is something we will discuss in a session. Second is data protection officer. There is a myth that any company which is operating in Europe have to appoint a data protection officer. It's a myth. Not every company needs to appoint data protection officer. So whenever we appoint, there are a lot of roles and responsibility, and also data protection officer role is something is legally attached as well. So there is a lot of nuances which we need to understand. And so what are the qualification criteria, what's his roles and responsibilities, and what are the do's and don'ts, and all these things we'll be discussing. Part of the data protection officer who can become a data protection officer is something which we'll also discuss. Codes of conduct and certification, this is one of the mechanism which any company like controller or processor can apply for under GDPR. This particular scheme is one of the first approved scheme for you to get a GDPR certification. Next is data protection impact assessment, one of the very important interview question as well, because many a times people still don't have a clarity about what is PIA and what is DPIA. So those important things are very very important from your exam as well as your day-to-day working perspective. I will clear those doubts in terms of what is the privacy impact assessment, what is the data protection impact assessment. For instance, I can give you a clarity. DPIA is a term which is coined only with GDPR, and PIA has been existing for last 20 years. And there are specific triggers for only that you will do a DPIA. Okay, and what are those triggers and all those things we will discuss in detail in our session. And next important point is data protection by design and default. So PBD, privacy by design, is a very important framework. We will be discussing a lot of nuances in terms of what are the principles of data privacy by design and how do we practically implement privacy by design. So there are a lot of concepts related to that, and all those things we will be discussing in detail in our sessions. So next important topic is your penalties. So there are two important categories of penalties, which are 10 million euros or 2% of global annual turnover, or the second slab, which is the highest slab, which is 4% of annual turnover or 20 million euros. So if you breach those categories, you will get that particular slab. There is also a lot of calculation related to that, in terms of how do we arrive at what are the factors which the authorities will consider before levying a fine. So we will be looking into what infringement will attract what type of penalty in detailed case studies. So that is more in terms of what are the important topics which we wanted to discuss. Okay, and I'll be moving on to the next topic, which is why CIPPE. So CIPP is a global industry standard for professionals entering and working in the field of privacy. CIPP credentials actually demonstrate a clear understanding of the principles and the knowledge base of information privacy. And mind you, these words are coming from the direct IAPP itself. So if you go and look in LinkedIn, you will see this is a benchmark for any data privacy rules in the market. So it clearly shows that this particular certification has a lot of value as it demonstrates the understanding of principles, framework, the knowledge base, as well as what are the latest topics like the Schrems 1, Schrems 2, judgments. All these things will be discussed in detail during our sessions. So you'll be recognized part of an elite group of knowledgeable and capable and dedicated data protection practitioners. So along with this, if you do CIPP will elevate your role leadership profile among the other colleagues. And once you complete CIPM along with CIPP, you will be uniquely equipped to fulfill the DPO requirements of the GDPR, which is very, very interesting. As we see, DPO is a mandatory appointment which is going to happen for many companies which are handling personal data and sensitive personal data. And the moment you complete these two certifications, CIPP and CIPM, you will be uniquely distinguished to fulfill the DPO requirement, which we are not marketing, but this is what is being said even at a IAPP level. As well as you go and check in any LinkedIn profile by yourself, you will find this. These are the two certification which has been mandated for all the profiles. Okay. And CIPP is a key benchmark among the top employers. There's a lot to know and there is a lot at stake, and there's a lot of opportunity for privacy professional. With the right training and education, you will definitely able to crack this particular certification. So how to approach this exam? I'll do a quick recap of how generally my students have cleared this particular certification. Uh, Students, basically I call them students or candidates because I get candidates sometimes with 15 years or 20 years of industry leaders join my session as well. So basically you have two important documents from IAPP. One is body of knowledge and second is exam blueprint. These two are publicly available document, but the body of knowledge is the curriculum. Exam blueprint gives you the exam weightage, what is the minimum and maximum mark that you can expect for each and every type of chapter which is there. The official textbook is by the Edward Ustran. I think now the third edition is available, and that book is really important for you to give one full reading. That is something which you should definitely do. There is a method how do I generally ask my candidates to prepare. I ask them to go through my session first, and then parallelly when you have a week break, go and read the book. I'll give you lot of reading materials during that week. Read it, come back, ask questions, clarify, then we move to the next topic. This is the way I ensure that within 1 month you'll be completely sure about the knowledge and the important topics of CIPP. Then, and a maximum you need to take another 30 days, which is for your exam preparation in terms of your Q&A. So in this way, you can be pretty sure by end of 2 months, you can definitely crack the exam. So many students of mine, I have definitely cracked this exam within a period of 2 months. It is definitely doable, but you need to put a good amount of hard work. The reason is this exam is a professional certification. It will require its own effort, and you need to spend a quite amount of at least 70 to 80 hours to clear this particular certification. But it's definitely doable is what I can guarantee you. The third is creating flashcards, something which I'll tell you what sites you can refer. You can directly get those flashcards whenever you're traveling, whenever you are getting free time. Just look at these terminologies time and again. It will definitely help you to remember. So create a study group. So you get a natural study group when you join my session with 10 member, 15 member. When you join these people, you discuss the questions, you get clarified, you get a lot of inputs from people joining from different sectors like healthcare, manufacturing, lawyers, from techies. So all these people from different background join my session. So it really helps you to get a lot of unique perspectives when you are doing this in a study group. Use question and answers to so I'll be sharing a lot of question and answer. You'll also part of the package will get the official Q&A from IAPP part of the package, and there are some good useful resources which I mentioned here. Kindly go through them. These are all open book materials which are available, which is quite legit in terms of exam preparation. The reason is don't go for dumps which are available in internet. Most of them have 60-70% of wrong answers, so don't fall prey to that. Don't trust on any exam dump which is for paid, because trust me, IAPP keeps looking at all these things and they ensure your questions are twisted and you make the mistake by looking into referring the exam dumps, right? So do not fall prey for these exam dumps. So if you look at the recent trends, This is something which IAPP is also showcasing, that the requirement for risk and privacy officer as well as the salary is skyrocketing right now. And even in India, when the DPDP bill is gonna be published, you will see a lot of openings for data privacy manager and data privacy officer or data protection officer role, which will be there in every sector. And that's a great step for anyone to stay ahead. If you complete the certification, you will definitely be one step ahead of many candidates who are still thinking about what to do. So these are some of the interview questions. What is the difference between data privacy and information security? What is the difference between personal data, sensitive personal data, and PII? Difference of anonymization and pseudonymization? Difference between PIA and DPIA? What are the different rights which are available for data subjects? Is it available to everyone? Is it only to data subject? What about European citizen? What is it available even to an Indian citizen? All those are interesting perspectives which someone can ask you. Do all companies need to designate a data protection officer? Difference between a privacy policy and privacy notice? What are the lawful bases under GDPR? What are the principles of GDPR? And finally, what are the ways that data can be transferred outside Europe?